What is the right against self-incrimination? The right against self-incrimination is found in Article 3, Section 17 of the 1987 Philippine Constitution, which states that no person shall be compelled to be a witness against himself. This is based on the grounds of public policy, because if the party were required to testify, it would place the witness under the strongest temptation to commit the crime of perjury, because it would prevent the extorting of confessions. The right is available to not only criminal prosecutions but also civil and administrative actions, as well as legislative investigations. The right against self-incrimination is bestowed to every person who gives evidence, whether voluntary or under compulsion of subpoena, in any civil, criminal, or administrative proceeding. In the case of Villaflor versus Summers, a criminal case pending before the Court of First Instance in the city of Manila, Villaflor and Floriento Sungmingao were charged with the crime of adultery. In this case, coming in before Honorable Pedro Concepcion, Judge of First Instance, upon the petitioner of the Assistant Fiscal for the City of Manila, the court ordered defendant Villaflor to become a petitioner therein, to submit her body to the examination of one or two competent doctors to determine if she was pregnant or not. The accused refused to obey the order on the ground that such execution of her person was a violation of her constitutional provision relating to self-incrimination. Thereupon, she was found in contempt of court and was ordered to be committed to Bilibid prison until she would permit the medical examination required by the court, leading to self-incrimination. Now, the issue: whether or not the accused to submit her body to examination of one or two competent doctors to determine if she was pregnant, a violation of her constitutional right against self-incrimination. It was held no. The rule that constitutional grantee that no person shall be compelled in any criminal case to be witness against himself is limited to a prohibition against compulsory testimonial self-incrimination. The corollary to the proposition is that the ocular inspection of the body of the accused is permissible. It is reasonable presumption that in the examination by reputable or distrusted physicians, due care will be taken not to use violence and not to embarrass the patient any more than is absolutely necessary. Indeed, no objection to the physical examination being made of the family doctor of the accused or by the same sex can be seen. As we see it, the object of having criminal laws is to purge the community of persons who violate the laws to great prejudice of their fellow men. Criminal procedure, the rules of evidence, the constitutional provisions are then provided not only to protect the guilty, but to protect the innocent. No rule is intended to be so rigid as to embarrass the administration of justice in its endeavor to ascertain the truth. No accused person should be afraid of the use of any method to which tend to establish the truth.
In the case of Beltran versus Samson, the facts are an order was given upon petition of the provincial fiscal of Isabela for the purpose of comparing the petitioner's handwriting and to determine whether or not it is he who wrote certain documents supposed to be falsified. Respondents contend that Beltran is not entitled to the remedy applied for, inasmuch as the order prayed for by the provincial fiscal and later granted by the court below, and against which the instance action was brought, is based on the provisions of Section 1687 of the Administrative Code and on the doctrine laid down in the cases of People versus Padilla, United States versus Tanpen, United States versus Ong Shu Hong, and the case of Villaflor versus Summers. Under Section 1687 of the Administrative Code, the fiscal and the proper judge, upon the motion of the fiscal, may compel witnesses to be present at the investigation of any crime of misdemeanor, but this power must be exercised without prejudice to the constitutional rights of persons cited to appear, and the petitioner, in refusing to perform what the fiscal demanded, seeks refuge in the constitutional provision contained in the Jones Law and incorporated in General Orders No. 58. Therefore, the question raised is to be decided by examining whether the constitutional provision invoked by the petitioner prohibits compulsion to execute what is enjoined upon him by the order against which these proceedings were taken. So the issue of this case is whether or not the writing of the fiscal stipulation by the petitioner for the purpose of comparing Beltran's handwriting and determining whether he wrote certain documents supposed to be falsified constitutes as evidence against himself within the scope and meaning of the constitutional provision under examination. The court held no, and the court cited or referenced other jurisprudence in this case. So in the case of Bradford versus People, the court held that whenever a defendant at the trial of his case, testifying in his own behalf, denies that a certain writing or signature is in his own hand, he may, on cross-examination, but compelled to write in open court in order that the jury may be able to compare his handwriting with the one in question. In the case of Sprouse versus Cobb, where the judge asked the defendant to write his name during the hearing and the latter did so voluntarily. The court also noted the case of People versus Molino, wherein the handwriting or the form of writing of the defendant was obtained before the criminal action was instituted against him. In these cases, the result cannot be compared to the case at bar, and neither their ruling may be applied to the present case because in comparison, in the case of Sprouse versus Kong, the defendant voluntarily offered to write to furnish a specimen of his handwriting. The court cited this case particularly because the court there was given prominence to the defendant's right to decline to write and to the fact that he voluntarily wrote or produced that specimen. The court stated here that writing is something more than moving the body or the hands or the fingers. Writing is not a purely mechanical act because it requires the application of intelligence and attention. And in the case of bar, writing means that the petitioner herein is to furnish a means to determine whether or not he is the falsifier, as the petition of the respondent fiscal clearly states. The court also said that for the purpose of constitutional privilege, there is a similarity between one who is compelled to produce a document and one who is compelled to furnish a specimen of his handwriting, because in both cases, the witness is required to furnish evidence against himself. But even supposing it is impossible to obtain specimen or specimens without resorting to the means complained herein, that is not a reason for trampling upon the personal right guaranteed by our Constitution. Although it might be true that in some cases, criminals may succeed in evading the hands of justice, but such cases are accidental and do not constitute the reason for being of the privilege. This constitutional privilege exists for the protection of innocent persons. The court says here that the present case is more serious than compelling the production of the document because here the witness is compelled to write and create by means of the act of writing an evidence which does not exist and which may identify him as the falsifier. It cannot be contended in the present case that if permission to obtain specimen of the petitioner's handwriting is not granted, the crime would go unpunished. And with respect to the judgments rendered by this court and cited on behalf of the respondent, it should be remembered that in the case of People versus Padilla, it does not appear that the defendants and other witnesses were questioned by the fiscal against their will, and if they did not refuse to answer, it must be understood that they have waived their constitutional privilege. Wherefore the court finds the present action well taken, and it is ordering that the respondents and those under their orders desist and abstain absolutely and forever from compelling the petitioner to take down dictations in his handwriting for the purpose of submitting the latter for comparison.
On the topic of the constitutionality of Article 3, the Bill of Rights brings us to the pertinent issue on one's right against self-incrimination. Chavez versus Court of Appeal come to grips when the main problem were in petitioner's assertion that he was compelled to testify against himself. It was on July 23, 1963 that a trial commenced against Roger Chavez at the Court of First Instance of Rizal in Quezon City. During the trial, Fiscal Gresham for the prosecution asked Roger Chavez to be the first witness. Counsel of Chavez opposed as it will only incriminate his client. However, Judge ruled in favor of the fiscal on the ground that the right of the prosecution to ask anybody to act as a witness on the witness stand, including the accused himself. Also, it was claimed by the presiding judge that shall there be any question that is incriminating in nature, will be the only time that the counsel for Chavez may interpose such objection. Also, and that the presiding judge also gleaned that the counsel had all the assurance that the court will not require the witness to answer questions which would incriminate him. Now, the Chavez case stemmed from a charge of qualified theft from a Ford Thunderbird car. The theft was committed with the help of a certain Luis Asistio alias Baby, who completed a deed of sale of the said Ford vehicle which belonged to Johnson Lee. In the morning of November 14, 1962, Chavez telephoned Lee and made an appointment for the sale of the Thunderbird vehicle. He introduced Ricardo Sumilang, alias Romeo Vasquez, as an interested buyer. Now, Sumilang and Lee agreed on the price of 21,000 pesos and went to Binondo to Johnson Lee's cousin, named D. Sean Luke Lim, who was then the registered owner of the said vehicle. With the payment to be held at Eugene's restaurant in Quezon City, all of them drove in the said Ford Thunderbird vehicle to the aforementioned restaurant. Chavez and Sumilang, pretending to get the money for the perfection of the sale of the Thunderbird car, left Lee and Lim alone. Now, when the two went outside to look for Chavez and Sumilang, they could no longer locate the pair as well as the lost Thunderbird vehicle. Now, concentrating on the main issue, we place our attention to the petitioner's assertion that he was compelled to testify against himself. The court held that Chavez was forced to testify to incriminate himself in full breach of his constitutional rights to remain silent. According to Article 3 of the Bill of Rights, no person shall be compelled to be a witness against himself, and such right is mandatorily required to secure every defendant a valuable and substantive right. It's been held that the court cannot extract from a defendant's own lips against his will an admission of guilt. Also, it cannot be said that the Chavez waived his right. For a waiver to be valid, it must be certain, unequivocal, intelligent, understandably, and willingly made. In the case at bar, Chavez did not volunteer to take the witness stand in his own defense. In fact, he did not offer himself as a witness. On the contrary, he claimed the right upon being called to testify. It was only the presiding judge's emphatic statement that the right of the prosecution to ask anybody to act as a witness on the witness stand, including the accused himself. And the defense counsel could not object to have the accused called on the witness stand. The impact of all this is that Chavez had to take the stand. He was thus deprived him of his will to resist. With no genuine consent underlay the submission to take the witness stand, the court ruled was to discharge Chavez from custody unless he is held or kept in custody or detained for any cause or reason other than the judgment.
In the case of Pascual versus Board of Medical Examiners, the facts are Arsenio Pascual Jr., petitioner appellee, filed on February 1, 1965 with the Court of First Instance of Manila an action for prohibition with prayer for preliminary injunction against the Board of Medical Examiners, now respondent appellant. It was alleged therein that at the initial hearing of an administrative case for alleged immorality, counsel for complainants announced that he would present as his first witness here in petitioner appellee, who was the respondent in such malpractice charge. Thereupon, petitioner appellee, through counsel, made of record his objection, relying on the constitutional right to be exempt from being a witness against himself. Respondent appellant, the Board of Examiners, took note of such a plea, at the same time stating that at the next scheduled hearing, petitioner appellee would be called upon to testify as such witness unless in the meantime he could secure a restraining order from a competent authority. The lower court ordered that a writ of preliminary injunction issue against the respondent, board commanding it to refrain from hearing or further proceeding with such an administrative case to await the judicial disposition of the matter. The answer of the respondent board, while admitting the facts, stressed that it could call petitioner appellee to the witness stand and interrogate him, the right against self-incrimination being available only when a question calling for an incriminating answer is asked of a witness. It further elaborated the matter in the affirmative defenses interposed, stating that petitioner appellee's remedy is to object once he is in the witness stand. For respondent, a plain, speedy, and adequate remedy in the ordinary course of law. Precluding the issuance of the relief sought, respondent board therefore denied that it acted with grave abuse of discretion. A decision was rendered by the lower court in favor of the petitioner appellee, hence this case. The issue in this case is whether or not the petitioner appellee can invoke his rights against self-incrimination and refuse to take the witness stand in an administrative case. The Supreme Court ruled yes. The Supreme Court affirmed the decision of the lower court. The appeal apparently proceeds on the mistaken assumption by respondent board and intervenors appellants that the constitutional guarantee against self-incrimination should be limited to allowing a witness to object to questions, the answers to which could lead to a penal liability subsequently incurred. It is true that one aspect of such a right is the protection against any disclosures which the witness may reasonably apprehend could be used in a criminal prosecution or which could lead to other evidence that might be so used. If that were all, then it becomes diluted. The constitutional guarantee, along with other rights granted an accused, stands for a belief that while crime should not go unpunished and that the truth must be revealed, such desirable objectives should not be accomplished according to the means or methods offensive to the high sense of respect accorded the human personality. Thus, the petitioner appellee can invoke his rights against self-incrimination and refuse to take the witness stand in an administrative case.
De La Cruz versus People. The petitioner here was Jamie De La Cruz, a police officer who was charged with violation of Section 15, Article 2 of RA 9165, the Comprehensive Dangerous Drugs Act. According to the prosecution, the NBI received a complaint from Corazon and Charito that Ariel, who was one of the live-in partners of Corazon, and the son of Charito, was picked up by unknown persons who were believed to be police officers for allegedly selling drugs. After that, an errand boy came to give a phone number to the complainants. During the call, complainants were instructed to go to the Gorodo police office, where they met James, who demanded them money worth 100,000 pesos, which was later lowered to 40,000 pesos, in exchange for the release of Ariel. After the meeting, they went to the NBI to file the complaint. The NBI conducted an entrapment operation. During the course of the entrapment, the officers were able to nab Jamie De La Cruz by using a pre-marked 500 peso bill dusted with fluorescent powder, which was made of the amount demanded by James and handed by Corazon. After that, petitioner Jamie was required to submit his urine for drug testing, which produces a positive result for having the presence of the dangerous drug. However, the petitioner denied the charge against him. The RTC and Court of Appeals found the accused guilty. Now the issue: whether or not the drug test was a violation of the petitioner's right to privacy against self-incrimination. It was held yes. The drug test is not covered by allowable non-testimonial compulsion. The constitutional right of the accused against self-incrimination prescribes the use of physical or moral compulsion to extort communications from the accused, and not the inclusion of his body in evidence when it may be material. Purely mechanical acts are not included in the prohibition, as the accused does not thereby speak of his guilt. Hence, the assistance and guiding hand of the counsel is not required. The essence of the right against self-incrimination is testimonial compulsion, that is, the giving of evidence against himself through a testimonial act. The RTC and Court of Appeals therefore both urged that they were held that the extraction of petitioner's urine for purposes of drug testing was merely a mechanical act, hence falling outside of the concept of custodial investigation. In the present case though, the petitioner was arrested for extortion. He resisted having his urine sample taken, and finally, when his urine sample was taken, it was the only available evidence that was used as his basis for his conviction for the use of illegal drugs.
Under the constitutional provision on one's right against involuntary servitude, the Philippine Refining Company Workers Union versus the Philippine Refining Company revolves around the right against involuntary servitude and how Section 19 of the Commonwealth Act No. 103 is not offensive against the said constitutional provision. Now, the Philippine Refining Company Incorporated versus the Philippine Refining Company Workers Union was scheduled for a hearing before the Court of the Industrial Relations on September 26, 1946, wherein said court renewed its effort to effect a temporary settlement before going on the merits of the petition. A series of conferences with both parties was held by the court before the CIR came out with an order. Now, after careful consideration of the circumstances and facts of the case, at that stage of the proceedings, the Court of Industrial Relations came to the conclusion that for the welfare of everybody concerned and for the interest of the public, and because the court might not be able to decide the case promptly regarding the issues involved, the striking laborers were ordered to return to and resume their work in the Philippine Refining Company on September 27, 1946. And at 7 o'clock in the morning, management of the respondent companies was also directed that they should accept those who went on strike beginning at that date. In case number 32, under the date of May 2, 1947, Philippine Refining Company Incorporated versus Philippine Refining Company Workers Union of the same court was pending a final determination of the case. Petitioning company filed with the court an urgent report to the effect that a strike was declared by the union at the plant of the company in Manila the morning of April 30, 1947. In view of this development and other facts of consideration set forth in the lower court's order of July 24, 1947, it ruled that the strike staged by the union is contemptuous and illegal because it is a violation of the law and order of the court. Consequently, the court authorizes the said company to hire such of the striking laborers and employees and new labor force as in its discretion it may see fit. The issue of this case is whether or not order dated on September 25, 1946 is in conflict with the constitutional prohibition on involuntary servitude. And the ruling of the court is no, the petition by the Philippine Refining Company Workers Union is denied because the court order of the September 26, 1946 enjoining a strike or walkout without the authority of the court was made after the hearing consists of series of conferences with both parties. Now, Section 19 of the Commonwealth Act No. 103 does not offend against the constitutional inhibition prescribing the involuntary servitude. An employee entering into a contract of employment after said law went into effect voluntarily accepts the given condition, among which is Section 19, or the implied condition that when any dispute between employer and employee has been submitted to the court or in this case the industrial relation for settlement or arbitration pursuant to the provision of this act, and pending awards or decision by it, the employee shall not strike or walk out of his employment when so enjoined by the court after hearing and when public interest requires. So the voluntariness of the employees entering into such employment contract has a free choice between entering into it or not, and with such implied condition, negates the possibility of involuntary servitude ensuing.
In the matter of petition for habeas corpus Sigifredo Aclaracion, the facts of this case are: Sigifredo Aclaracion functioned as a temporary stenographer in the Gapan Branch of Court of First Instance of Nueva Ecija from October 1, 1969 to November 21, 1971. Thereafter, he was employed as a stenographer in the Public Assistance and Claims Adjudication Division of the Insurance Commission, where he is now working. After Aclaracion had ceased to be a court stenographer, the Court of Appeals required him to transcribe his stenographic notes in two cases decided by the Gapan Court which had been appealed, which is the case of Moncal versus Eugenio and Paderes versus Domingo. He failed to comply with the resolutions of the Court of Appeals. He was declared in contempt of the court. The chairman of the 3rd and 7th Division of the Court of Appeals respectively ordered the Chief of Police of Makati Rizal to arrest Aclaracion, a resident of that municipality, and to confine him in jail until he submits a complete transcript of his notes in the said cases. The 3rd Division of the Court of Appeals in its resolution ordered the release of Aclaracion. Later, he transcribed his notes in the Mungkal case. However, the warden did not release him because of the order of arrest issued by the 7th Division. Aclaracion filed in this court a petition for habeas corpus. He advanced the novel contention that to compel him to transcribe his stenographic notes after he ceased to be a stenographer would be a transgression of the rule that no involuntary servitude in any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. At the hearing, this court resolved to order Aclaracion's provisional release on condition that within 20 days thereafter, he would complete the transcription of his notes in the Paderis case in his office at the Insurance Commission, Manila. Aclaracion manifested that he had transcribed his notes in the Paderis case in his office at the Insurance Commission after he was provided by the clerk of court of this court with the requisite supplies. The issue in this case is whether or not there was a transgression of the rule, no involuntary servitude in any form shall exist except as a punishment for a crime whereof the party shall have been duly convicted. The court ruled no. The Supreme Court ruled that the contention of the petitioner is not tenable. Involuntary servitude denotes a condition of enforced compulsory service of one to another, or the condition of one who is compelled by force, coercion, or imprisonment, and against his will, to work for another. None of these can be found in the case. However, in view of the fact that Aclaracion might have acted in good faith and not complying with the resolution of the Court of Appeals in the Paterno case, due to the pendency of the instant habeas corpus case, the fine of 150 pesos imposed on him is hereby remitted.
In the case of People versus Estoista, the firearm with which the appellant was charged with having in his possession was a rifle and it belonged to his father, Bruno Estoista, who had a legal permit for it. The father and son lived in the same house and a little distance from a 27-hectare estate belonging to the family, with which was partly covered with cocoa grass, tall weeds, and second-growth trees. From a spot in the plantation 100 to 120 meters from the house, the defendant took a shot at a wild rooster and hit Diragon Lima, who was a laborer of the family who was setting a trap for the wild chickens and whose presence was not perceived by the accused. The evidence is somewhat conflicting on whether the owner of the rifle was with the accused at the time of the accidental killing. Bruno Estoista testified that in the morning of the accident, his son told him that there were wild chickens in the plantation who were scratching palay and corn plants and asked him if he might shoot them, and that Bruno told his son to wait, got the rifle from the house, handed it over to Alberto, who is a sharpshooter and shoots better, and walked about 20 meters behind the young man. That Bruno was that far from Alberto when the latter fired and accidentally wounded their servants. The defendant's key testimony is that when he heard a wild rooster crowing, he told his father about that and said that the wild rooster was crowing near their house, and his father told him to shoot the said wild rooster, so he then went to shoot it. Bruno's testimony at the trial is in direct contradiction to his and his son's statements at the constabulary headquarters on the same morning of the shooting and sworn to by them for the justice of peace soon after. Bruno related on that occasion that Alberto went to hunt for wild roosters, that later on his son Alberto came to inform him that they had accidentally hit their laborer, and that thereupon he went with his son to see what happened. When he was asked who was with Alberto when he went out hunting, Bruno replied that he was alone. On his part, the defendant declared that on the same occasion that Diragot Dima, after being shot, requested to be taken to his house, or to Dirma's house, and that as the accused was able to carry the wounded man only 50 meters, Dima asked the defendant to call Bruno, who was in the house, which Alberto did. To the question who his companion was when he shot a rooster, Alberto said that he was alone. So the issue in this case is whether or not the punishment of imprisonment from 5 to 10 years for possessing or carrying a firearm cruel or unusual. The court held no, imprisonment from 5 to 10 years for possessing or carrying a firearm is not cruel or unusual, having due regard to the prevalent conditions which the law proposes to suppress or curb. The rampant lawlessness against property, person, and even the very security of the government, directly traceable in large measure to promiscuous carrying and use of powerful weapons, justify imprisonment which in normal circumstances might appear excessive. If the imprisonment for 5 to 10 years is out of proportion to the present case in view of certain circumstances, the law is not to be declared unconstitutional for this reason. The constitutionality of an act of the legislature is not to be judged in the light of exceptional cases. Small transgressors for which the heavy net was not spread are like small fishes, bound to be caught, and it is to meet such a situation as this that courts are advised to make a recommendation to the chief executive for clemency or reduction of the penalty. The Supreme Court held that the trial court erred when it imposed a penalty below than what was provided under the law. However, considering the degree of malice of Alberto, application of the law to its full extent would be too harsh, and accordingly, it is ordered that the imprisonment imposed should only be reduced to 6 months. But later on, a resolution was issued and the judgment is then modified so as to sentence the accused to imprisonment for 5 years. This has been Group 7 and thank you for watching our report.